Hello, this is Matt on the Moon Lambo channel. I learned something from attorney Jeremy Hogan today. As it turns out, about 40 years ago, the SEC tried to make an end run around one of the prongs of the Howey test. So, look, the Howey test's been around since 1946. Thanks to the Supreme Court of the United States, it became the law of the land. And as it turns out, it's not only in recent times that the SEC has tried to get around that because they seem to not like it. Even 40 years ago, before I existed, or around the time when I was born, they were doing the same crap, pulling the same things. Now, as far as I can tell, the SEC is far worse, far more toxic agency than it has ever been in the past, but still, the point's not lost on me. They were not acting in good faith even back then. And so I want to share with you what Attorney Hogan had to say. Also, I have some comments from Attorney John Deaton having to do with some stuff from Gary Gensler, and a comment from David Schwartz, Ripple CTO, co-creator of XRP and the XRP Ledger. He was talking about advice, basically, for anybody that's in the world of crypto. Maybe you're doing a startup. He had some thoughts about, the implications for such entities given the state of things from a legal perspective in the United States. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, here's a headline from Bitcoinist. Binance versus SEC. Paradigm files an amicus brief, accuses SEC of regulatory overreach. Now, I'll note that this story was reposted on X by CZ, founder and CEO of Binance, the world's largest cryptocurrency exchange by volume, and he's got a little shruggy emoji there. And ultimately, Attorney Jeremy Hogan reposted this, which is why I want to make sure I cover this first so that you understand with sufficient context where this is all coming from. So let me cover just a small part of this article, and then I'll share with you what Attorney Hogan had to say. A crypto research firm, Paradigm, has filed an amicus brief in the ongoing court case between the U.S. Securities and Exchange Commission and Binance, its U.S. affiliate Binance US, and the exchange's global CEO they wrote it weird. They wrote Chow. It's Zhao. Changping Zhao, CZ. See, look, that's crypto media for you there. It's a bunch of C students. You're gonna see it. It's like type it up. Gonna go on the internet forever. Type. Spell check. Nah. Let's not do any spell check or reread it. Make sure that sentences are structured properly, or even factual content necessarily. Let's not worry about those things. We're crypto media. We're a bunch of C students. It's gonna be fine. And so that's the actual thought process. That's what's actually stated before every crypto media article in existence gets published to the webernets. That's a fun fact. Now you know. Piece continues. Back in June, the U.S. top securities watchdog launched a lawsuit against the defendants, accusing them of operating unlicensed exchanges, broker-dealers, and clearing agencies, among 13 charges. In a statement released on September 29th, Paradigm, who claims to have zero interest or investment in the defendants, has taken a stance against the SEC, accusing the commission of governmental overreach. According to Paradigm, the SEC is attempting to bypass the rulemaking process and rewrite the law, utilizing the disturbing allegations, in quotes there, in its lawsuit against Binance and its co-defendants. The San Francisco-based research firm backs its claims by firstly stating that the SEC's prayers being granted would mean that the U.S. court accepts the commission's theory that an investment contract does not necessarily need a contract. Now, folks, does that sound familiar? That's at the core of Ripple's final arguments when they filed, and I guess, when did they file? Was it technically September, or maybe I think it was the September, could have been October, a year ago, when they filed their motion for summary judgment to Judge Torres. When Ripple did that we found out that's the moment when we found out. At the core of Ripple's argument was that you can't have an investment contract if there's not an actual contract. Which still is a pretty damn good argument, don't you think? Maybe just common sense, even if you're not an attorney, and I'm not one, I just play one on YouTube. But even if you're not an attorney, doesn't that kind of make sense? Investment contract with no contract? Duh. Exactly. It doesn't make any damn sense. So Attorney Hogan reposted what CZ, founder of Binance, shared, that article, and wrote the following while sharing the screen grab. Now, this screen grab is from a case called, let's see, SEC v. Belmont Reed and Co. Yeah, the SEC v. Belmont Reed and Co. And I'm not going to read it because it's not necessary for the purposes of this video, but I wanted to make it full screen so that in case you want to pause and read it, have at it. But here's what Attorney Hogan had to say in reference to what I just shared with you and what's on your screen here. It really just has to do with the fact that the SEC doesn't like the Howey test because it's inconvenient for the legal argument, so they try to get around it. Just like they did in the SEC v. Ripple case. These pricks. My God, the audacity. These douchebag people. So here's what Attorney Hogan said. The SEC attempted to make an end run around the third prong of the Howey test back in the early 80s when inflation was high and gold was the investment. And back then, as well, the courts reminded the SEC that the expectation of profits cannot come from market forces. So folks, think about this. Inflation was high, so people were fleeing the dollar and putting it into gold, so that's the expectation of profit, and there you go. The Howey test. They were trying to get around it even then. And so different parameters for the situation, same douchebaggery from the same SEC. Different humans working there now, but I guess they just keep hiring more of their kind. As they're leaving, they just keep hiring more of their kind, the little spawns of Satan. Winged creatures. Ugh. Here you have a post from XRP community member Wheezy. And take a look at this. And this is from June of last year, actually. Shared this video clip of Gary Gensler, who was speaking. And this was it's a clip from 2018, actually, so far before he ever knew he potentially even would have been SEC chair. But Wheezy here wrote, so it looks like Gary Gensler agreed that, number one, the Hinman speech was not personal opinion, and number two, Ether transformed from a security to a non-security. And so that was reposted by Attorney John Deaton tonight, actually. And here's what Attorney Deaton had to say. Oh, actually it was the morning, so it was today, but it was the morning. What he said, I don't care that Gary Gensler taught at MIT. The man has no clue what is or isn't an investment contract, also known as a security. According to him, if an asset is being promoted by someone, it transforms the asset into a security. He completely ignores the fact that U.S. securities laws do not apply to the purchase of an asset for non-investment use cases. If you asked Gensler what the U.S. Supreme held in the Foreman case, he's talking about the U.S. Supreme Court, do you think he could tell you? I doubt it. More importantly, he doesn't give a S-word what the law says. The SEC has publicly admitted that it ignores the common enterprise factor of the Howey test. It's on the SEC website today. Gensler must go. And so, folks, and I've highlighted that multiple times over the last couple years or so, the SEC literally states what is required by the Howey test per SCOTUS, so Supreme Court of the United States, and then they just say, but we don't require it. We at the SEC. That is what the SEC actually argues. It's unbelievable that they're actually doing. I mean, I know you believe it because you've been following this crap for probably a long time, probably as long as me, many of you anyway. It's absurd. So they were doing this crap in the early 80s, as pointed out by Attorney Hogan, which I didn't realize, and here we are, 4 decades later, doing additional douchebaggery stuff. Like, thanks for nothing, you pricks. It grinds my gears, son. And now, by the way, guys, you remember the whole Stoner Cat situation with the NFTs? That was there were a bunch of famous people involved. I know Mila Kunis is involved with it. It was, the most famous, I would argue, for being on the 70s show. Although also somebody pointed out after I should have thought of this too, with Family Guy. You gotta love Family Guy. That show's hilarious. The voice for Meg. But anyway, so she's involved with Stoner Cats, and the SEC pushed back against them, and then there ended up being a settlement, just destroying this whole thing. And so XRP community member Muse Forge wrote to Attorney Deaton and said the following. This is how Stoner Cats was basically accosted by the SEC and shut down with brute force. Have you read the evidence the SEC used to bully Stoner Cats into a settlement and into destroying the cartoon that the community helped bring to life and even had voice parts in, not to mention they have to burn all their NFTs? It was 3 solitary tweets. 2 statements and a meme is what the SEC used as evidence of a violation to scare this lighthearted project into oblivion. So folks, think about that. As stated here, and I'll take him at his word here, 3 solitary tweets, that's all the SEC needed to push the participants here in this case to settle. Because otherwise, what would you have? A multi-year litigation costing untold millions of dollars. It's easiest to just settle and just be done with it and move on with life, which is what most entities and most people choose to do. And it's easy to understand why, frankly. But it's pretty gross, isn't it? So this is where David Schwartz jumps in. David Schwartz responded to that and wrote the following. The net effect is that projects are being given 3 pieces of legal advice. Number 1, avoid anything that would give U.S. regulators jurisdiction. Number 2, avoid truthful disclosure of future plans. And 3, avoid perception that you are making efforts. How does that protect investors exactly? You think about it. So the participants in the project, to make sure that you don't get attacked, don't disclose stuff. That's right. Make sure people out there, investors, have less information so that you don't get attacked by the SEC. See how backwards this is? What the SEC is doing is harming investors. And regardless of the intent, that's what they're doing. Even if it's for selfish purposes, regulatory capture, they think that their bosses are going to like that if they fight for it, so whatever the reasons are. The end result is that it harms the investor that they're sworn to protect. They know this, and they don't care. So whatever the rationale is, they're aware of it, and they're disgusting, terrible people. That's as far as I'm concerned, that's it. What a despicable government agency. Absolutely despicable. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.